the times where people ignore the red flags and say, let's just keep pushing, those are the times where you fail. I mean, I acknowledge I have a massive unfair advantage by, having the entertainment industry as sort of this this microphone or this boost that I get to, sort of help promote my businesses with. That's sometimes hard as a woman because, you question if you're being difficult or if you're too in your head.
They begged me not to show it to them. It's actually 3,000, but who's counting? And the movie wasn't done yet. No, we were still editing it. It was close. And also Colleen was so involved in this. She's such a great filmmaker. She was able to stand up for the book.
Hey besties, it's Katie from Without a Crystal Ball. Welcome back to my channel. Well, it's been a busy couple days. Listen, Justin's team put out a statement and they said that they are not going to amend their complaint, the second amended complaint. We know this by now, right? And they said that instead of trying to revise what was left of what the judge decimated, they are going to vigorously defend the case that Blake brought against them because it's baseless, and they are going to pursue other legal options. A statement was released by Friedman to the press, which said the court's decision on the motion to dismiss has no effect whatsoever on the truth that there was no harassment nor any smear campaign, and it does not in any way affect our vigorous defense against Ms. Lively's claims. Discovery is proceeding, and we are confident that we will prevail against these factually baseless accusations. Instead of revising the existing claims, our clients will be pursuing additional legal options that are available to us. So that obviously has led a lot of people to question, what does that even mean? And obviously Blake is claiming total victory, right? So she's saying that she was completely vindicated and that the whole lawsuit that they filed was totally baseless and frivolous and done in retaliation and blah, blah, blah. And, of course, she's on 100% victory tour. But her victory tour obviously is premature at this point because she still has a whole case that she needs to prove in court. Now, it can feel like a relief when you have a lawsuit that's weighing on you, that people are accusing you of wrongdoing. Once that is gone, you can feel relieved about that. But she still has to prove her claims against Baldoni. And Baldoni does have other legal options here. And other legal options can be that if, say, he were to prevail in court and he were to win and her whole case is dismissed, he could sue her for malicious prosecution. He could also file a lawsuit for abuse of process, which is misusing the court system and filing a lawsuit for an ulterior motive. They could pursue an abuse of process lawsuit for the Van Zandt sham subpoena, which we'll talk about here in a second because they have finally compelled that, or they could appeal. And appealing is something that can be done at any time when an order is given that you don't agree with. And in a motion to dismiss, when an entire case is decimated, you can actually go to an appeals court to appeal the decision. Anytime a case is dismissed with prejudice, what that means is it's a final decision on a case. And so when a case has a final decision, any of like that, it can be appealed. And I spoke to a lawyer who actually is a Harvard Law School graduate who wants to remain anonymous. And I asked them what grounds would be for an appeal in the motion to dismiss. And their belief was the judge applied the wrong standard, especially in the context of Ryan Reynolds and possibly Leslie Sloan. Neither of them enjoyed privileges to shield them like Blake Lively and the New York Times. At 12b-6, all inferences are to be construed in favor of the non-moving party, Wayfair. The judge applied summary judgment type reviews and started talking about facts. That's not appropriate at dismissal. And then not allowing them the opportunity to amend is a reversible error in mine and many other attorneys' opinions. And then they also said one example was that the judge opined it would be reasonable for Ryan Reynolds to believe his wife and thus assert that Justin is an S predator. Ryan Reynolds' frame of mind and whether it was reasonable is not a consideration. Another area where the judge, I think, was starting to talk about facts versus law was when he decided that Blake using threats in order to get what she wanted or to breach her contract or to get a cut of the film, he called that hard bargaining. And that to me, and I'm not a lawyer, that felt like he was deciding that it was a fact that using threats like that is actually a hard bargain because there's a difference between hard bargaining and threatening. And he didn't seem to think that her threats were anything more than hard bargaining. And I don't know that that's true. And I don't know that he had a right to make that decision at a motion to dismiss where we're talking about the law. So there's definitely ways that they could, according to the people I've talked to, appeal this. But other issues that could come up is what if there was evidence that was submitted to the court that was provided under duress or threat? Well, there is one piece of evidence that was relied on pretty heavily. It was in at least from the pages of like 90 to 110 discussed by the judge. So encompassing about 20 pages, not referenced on every single one of those pages, but it was a declaration which was filed by the Daily Mail reporter, James Vasuka. And the declaration was for Leslie Sloan, and it related to a 193, paragraph 193, where the amended complaint said that, and worse yet, Melissa Nathan had heard that Leslie Sloan had told someone that Justin had sexually harassed or sexually assaulted Blake. Leading up to this part, they are talking about Leslie having a conversation with this Daily Mail reporter named James Lasuka. They share some of the text messages, but to be clear, the text messages that she's referencing in this amended complaint are not included. So, and I'll just read this to you. Despite their agreement, Nathan was completely unaware that Sloan had provided the reporter with information that significantly altered the narrative of the published story. Indeed, the reporter originally sought to publish a story about Blake being labeled difficult on set. And after the reporter's discussion with Sloan, however, the story changed to, "We have learned that Justin Baldoni caused issues on the set." Not only did Sloan breach her agreement with Nathan, but she planted false and defamatory information about Baldoni to distract from Lively's numerous missteps and throw Wayfair and Baldoni on the defense. So they're saying that story, I think the disturbing truth about what happened on the set of With Ends It Up, the truth behind why Blake Lively is feuding with Justin Baldoni revealed. And that included the stuff about, Justin being abusive and chauvinistic and not taking her point of view into play and discounting her, and no man should be able to, direct abuse scenes, and he became his character and people really didn't like him, all that. And then 193 says, following the release of her administrative complaint on December 20th, 2024, the same Daily Mail reporter informed Nathan that Sloan had lied to portray Baldoni as the foe. Yet still, Sloan escalated the false narrative by telling the reporter that Blake was sexually assaulted, an unsubstantiated accusation that not even Lively had gone so far as to claim, designed to destroy Baldoni and his reputation. So that part of it was after the stuff that was put out in August. Okay. And as far as I know, that what they're talking about has to do with him contacting them and saying, what are they talking about? Leslie never told me that Blake was sexually harassed or sexually assaulted. Those text messages were included in the New York Times lawsuit that was filed in California, but were not in this lawsuit. And this is an error because he never said that. The text message that was in the complaint is one from the Daily Mail reporter, and it says, she said the whole cast hates Justin and this has nothing to do with Blake. And now she's saying that Blake was sexually assaulted. Why wouldn't she say anything about that then? She knows she's full of SHIT. She told me that the whole issue was that everybody hates Justin, nothing about Blake and Justin, and she said it had nothing to do with Blake. Bullshit. So my guess is that he used sexually assaulted instead of sexually harassed, and he was probably talking about what had been put out in the CRD because he was responding to the CRD. Either way, she's using this to sort of prove that everything that she told the Daily Mail other than that is all somehow irrelevant, which is really unfortunate because it's like the judge ignored everything else, right? And she gets him to sign a declaration after she subpoenas his records, and they subpoenaed his records after the Van Zandt Inc. lawsuit was discovered by me. And his declaration said this: I have personal knowledge of the facts set forth in. I am the Daily Mail reporter that authored the text messages that appear in paragraph 193 in the Wayfair Party's amended complaint in this action. In those text messages, my use of the phrase sexually assaulted was a mistake. I meant to say sexually harassed. I regret this error. Further, this phrase was in reference to the allegations in the CRD complaint that Blake Lively filed with the Civil Rights Department in California. Phrase was not in reference to any conversation that I had with Leslie Sloan. Miss Sloan never told me that Miss Lively was sexually harassed or sexually assaulted by Justin Baldoni or anyone else. The Wayfair parties and their counsel did not consult me about what I meant by my use of the term sexually assaulted. I did not authorize the Wayfair parties or their counsel to include my text messages in their filings, and I regret that the private text messages were made public. I declare under the penalty of perjury that the foregoing is true and correct to the best of my knowledge and belief. And then it was signed on June 4th. So then she files this in court and she basically claims, I am vindicated because I never told him that. And she used that and she spread that to the media. And just right off the bat, there's a couple issues with what she's saying is the full context of those texts that were used were in the New York Times complaint, but not in this complaint. So we only got one copy of them, right? But the one issue that I had when I saw this was the sixth part. And it says the Wayfair parties and their counsel did not consult me about what I meant by my use of the term sexually assaulted. I did not authorize them or their counsel to include my text messages in their filings, and I regret that private text messages were made public. When I first saw that, I was like, well, first of all, he was not at all on Leslie's side here. And if he sent that text to Brian and if he sent that to Melissa, they're literally parties in a lawsuit, or Melissa is. And any evidence that she has about Leslie can be used in court. So if she gets a text from a reporter, that can become evidence because it's from her text messages. Same with Brian. If he gets something from someone and they tell him something, he can bring that to court as evidence. So they didn't need permission. This isn't like you're publishing a magazine and you need legal to run through whether or not you can use someone's text message because the evidence belonged to Melissa Nathan and to Mr. Friedman. And they don't need permission to include them in a filing. They don't need permission to use them as evidence. And I don't know why there would be any regret about private text messages being made public when the reporter himself knew that he was doing this to help them in their case. And that's evidenced by the further text messages that were shown. I noticed in here that they used the word regret or mistake multiple times, which honestly means that he's admitting to liability here, right? My use of it was a mistake. I regret this error. I regret the text messages becoming public. Regret suggests liability and suggests that it was his fault when it wasn't his fault and he did nothing wrong. But what if I told you that there's more to what happened with that declaration? And it wasn't just that this declaration was filed, but it was that the reporter that filed this declaration was coerced and threatened by Daily Mail and told that if he didn't sign this, he would be fired and that he had to sign it regardless. And what if I told you that one of my sources said that there was evidence that this reporter told them over and over and over again he did not want to sign this. He knew it wasn't truthful. He knew specifically that number 6 was not truthful. He knew that there was issues with all of the numbers, in fact, of what was said because it wasn't clear about what was being said. And she was stripping away the ability to actually tell a full narrative, right? And then what if I told you that this was filed with the agreement which Leslie Sloan told the court that as long as he filed this, she would drop her subpoena against Daily Mail. So basically, Daily Mail forces their reporter to file a declaration under the penalty of perjury that the reporter knows is not true and that the reporter knows doesn't represent what happened and doesn't represent his communications with Wayfair and doesn't really represent fully his communications with Leslie as it pertained to Justin Baldoni, because it's only one comment. It has nothing to do with everything else that she told him. And that reporter wanted to tell the truth, but Daily Mail was infringing with his ability to testify truthfully and honestly about what happened. And then as soon as this declaration was filed, there was a subpoena granted or filed Brian Friedman, who wanted all documents related to what went down with this declaration and communications as it related to his communications with Leslie and about the film and about Baldoni and about Lively and all of this. And when she filed this on a Friday, by the next Monday, the case was dismissed. And this declaration was cited on like 20 pages or used in about 20 pages to dismiss an entire case against Leslie. And it's based on fraud and it's based on coercion and it's based on threat. And he didn't want to sign it. And then he only signed it because Daily Mail allegedly forced him. Well, I was told by multiple sources that they are currently working with Wayfair attorneys to get this declaration withdrawn and corrected for the record so that the real testimony of what happened when it comes to Leslie Sloan and the Daily Mail can be told. And the Zuka apparently has been given whistleblower status. So he is considered a reporter whistleblower, which means the Daily Mail can't fire him for telling the truth. And they can't obstruct his ability to testify in a case and provide truthful testimony. The Daily Mail had an incentive here, in my opinion, to get him to sign something so that their liability in this case would be diminished. Because if she did provide evidence or statements to him that were false and defamatory, that cast him in a false light, that is actionable, specifically if it was done intentionally to cover up what Blake did. So, and if he has evidence of all of their conversations, there would be incentive for Leslie and for Daily Mail to want to have him silenced so none of that comes out publicly, right? And so if they're obstructing in that by having them sign this and it's not true or representative of what happened, I was told that they're working and in process of having this withdrawn, and he hired new attorneys for this purpose. So I was told that after this was filed, there was like a lot of issues that happened, and he was being represented by counsel for not only Daily Mail, but also him. So it was like in-house counsel for Daily Mail. So technically speaking, they had the best interest of the company in mind, even though his subpoena was to him alone. And he went out and sought private counsel for himself and only him. And he fired his previous attorneys that were Daily Mail's in-house attorneys. And Mark Garagos's law firm is now representing him. And it is not because he did anything criminally wrong. It is not because he's needs a criminal attorney. They handle complex civil litigation. Garagos does, and his team. But not only could this impact Blake's case, but the Daily Mail could potentially be facing a lawsuit for this obstruction of some sort with a reporter testifying. And Daily Mail will probably argue that, they want to protect the sources so that sources come forward and so that it doesn't harm the reputation of their paper. And sure, but in this case, Leslie identified herself as the source. Leslie, in her declaration, identified her as the source. She admits to giving information to the Daily Mail and to Page Six. So if the source is willingly identifying themselves, it's very different than James outing her. And he could have used reporter's privilege, which Sarah Nathan did, but he wanted to tell the truth because of what he knew and what Leslie had told him. So how to have an affidavit withdrawn comes down to Wayfair would have to file in court, and then a new declaration or an affidavit would have to be submitted to correct the record. But anytime something has been provided to the court that's inaccurate, you need to correct the record as soon as possible. Knowing there's concerns here that what's in this declaration or sworn affidavit is not truthful or contains false statements they would want to notify the court as soon as possible about this. And in federal court, there's a couple ways that you can do this, but obviously he needed to get a lawyer, so he got new lawyers, and then he needs to try to correct the record. So he, via his attorneys or with the help of Wayfair, they can file an affidavit of correction, and it's a legal document referring back to the original affidavit, and it outlines the untrue statements and replacing them with the correct information. They also can file a motion with the court to amend or withdraw the affidavit. And so if they do a motion to withdraw it, they would have to provide clear and factual statements explaining the reasons for the withdrawal, such as discovering new information or identifying an error in the original document. They need to provide a valid reason for the withdrawal. So explain what you made, the error that you made, and are retracting. So in this case, the reason would be that it was signed under duress, under threat, coercion, threats of his losing his job, and then he would need to wait on the court approval. Because there's this concept that there could have been coercion or threats or intimidation used in order for him to file this, and there could have been this idea that obstruction of justice happened, where that they're trying to interfere or impede his ability to participate in testimony or providing accurate testimony or documents to the court. That also could be disclosed as grounds for why they would like to correct this. Blake's side would obviously have an opportunity to argue why they shouldn't, but anytime someone files information in court that's not accurate, it needs to be corrected as soon as possible. And especially in a case like this, where they're relying so heavily on it for the case for the motion to dismiss, along with first, her getting attorney's fees and vindicating herself and trying to change what the testimony is about her, they need to correct this as soon as possible. And could that impact the case? Maybe, yes. I mean, if it's reversed and a new declaration is provided that outlines a different set of circumstances that the judge can use to revise and look at the case, yes. Could it reverse the decision because now there's question about the intimidation and the coercion and the obstruction that could have happened? Yes. There's a lot of steps that would need to happen before that goes there, but they definitely have many legal options still. And what is appears to be here more than anything is that Leslie was in some way trying to, and the Daily Mail were trying to silence a reporter that had information about what Leslie told them in August of 2024. Even if it wasn't about sexual assault or sexual harassment, it could have still very well been defamatory. It still could have very well been information that was published in false light or that was outright lies, and they knew it was lies. Like, one of the things that Leslie told the Daily Mail was that Colleen demanded script rewrites. They had to be done. That's why, even though that's not what's true and that's not what the evidence shows. There's also, she said that Justin was abusive and chauvinistic. That in and of itself could be deemed defamatory. It's painting him in a light that he's not a good guy. It also could just be deemed as an opinion, It really just depends, but it still would show that Leslie was seeding information to Daily Mail. So then is it really retaliation, right? So it also could be used in defense. So if they're trying to silence James from providing evidence for Wayfair's defense, that also is a huge, big problem, right? So my sources say they're going to be working to have this withdrawn or amended so that the accurate information is reflected and it is known what was done behind the scenes. This was confirmed to me by multiple sources. And as far as what this means for the case being reversed, that I don't know. This definitely would help the defense of the claims against that Blake has brought against Wayfair. And if they want to just focus on that, they have at it. Will they possibly appeal this to the court, to the appeals court on their full dismissal with prejudice? They have until July 9th to make that decision. So we'll have to wait and see. Let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, everyone.